Hello there, everybody. I am Kizzy Augustin. I am a health and safety and fire safety defence lawyer and partner at Russell Cook in London. And I specialise in defending and representing organisations and individuals in respect of health and safety, fire safety investigations and prosecutions, as well as doing a bit of this. It's advising duty holders on how to proactively seek compliance within our complicated regulatory regime. And what I want to talk about really is fire safety in this post-Grenfell world. Are we going far enough in terms of the legislation and guidance? I think fire safety certainly has been a critical concern of ours, since Grenfell in 2017. The issues that come up certainly include ignorance of our building regulations within the construction industry, a bit of an indifference into the potential consequences of getting it wrong, lack of clarity over the duty holder roles and responsibilities, and a lack of regulatory oversight. There's lots of focus on residential building, as we all know, and high-risk buildings, which we'll come to a bit later. But we mustn't forget those commercial buildings and those that house vulnerable persons. We've got legislation in place now, as I've got in the slide in front of us. We'll talk about what's in place now. But does it go far enough? Do we need more, and do we need it probably more quickly? So let's just have a quick recap on what we've got in place now. Since Grenfell, we already had the Regulatory Reform Fire Safety Order, which covers all commercial buildings and the common parts of residential premises. And it comes up with issues such as the responsible person, what parts of the building you need to deal with, what sort of mitigation measures need to be in place. And let's have a look at that. Who is the responsible person? This is one of the duty holders that we will go on to speak about as we move forward in today's presentation. But the definition is here. I'm not going to go through this in too much detail because I'm going to presume that a lot of you who are listening in are very aware of the fire safety order and the responsible person and what different parts of the regulatory reform fire safety order comes up with, such as maintenance and having the right exit signs in place and making sure that you've got mitigation measures and preventative measures in place. But let's look at the responsible person, because I think that's where there's been a lot of talk about whether we're not going far enough to define that role and responsibilities that are attributable to that person. So the definition is in Article 3 of the Regulatory Reform Fire Safety Order. I'm going to call it the RRO from now on. Who has personal liability? That is normally the owner, the occupier, or the general person who has control over that building. So that's usually the responsible person who has liability, but there is a wider range of people who can have responsibility under the RRO. Those wider people are also called responsible people under Article 5.3 or 5.4, doesn't matter what article it is, but what matters is who are those wider persons? Who are those additional duty holders? Every person who has control of the premises to any extent, so far as requirements relate to matters within their control. That is generally by way of a contractual arrangement or a tenancy if you're in a residential leaseholder landlord situation, and there are obligations within that document regarding maintenance, repair and or safety. That person will be in control of the premises to the extent of what it says in that document, to the extent of the amount of maintenance they have to do, the amount of repairs they are responsible for. So yes, they are a responsible person, but only to the extent of their control. Then you'll see the wider corporate fire safety responsibilities which we have under the RRO. It's this duty to take general fire safety precautions as will ensure, so far as is reasonably practicable, the safety of employees, and also those non-employees, you have to take general fire precautions that may reasonably be required in the circumstances to ensure that that premises is safe. That is the overarching corporate responsibility under the RRO. We mustn't forget that there is also an additional duty holder responsibility. Article 32.8 talks about the responsibility of a senior person, a director, a senior manager, who by way of, if they have breached the law by way of their consent, connivance, or attributable to their neglect, then that individual, that senior individual, whether you are named a director or not, that senior individual, as well as the organisation, will be guilty of a fire safety offence. So those are the things that we have in place at the moment. And I think what's really important, and has been important over the last couple of years, certainly, has been looking at what the new legislation is going to do. So we're fairly familiar with the RRO, we're fairly familiar, even those of us who do a bit of health and safety, we're aware of the corresponding responsibilities under the Health and Safety at Work Act as well, which are very similar to the ones we've just outlined. But if we look at the new legislation, for example, the Fire Safety Act, one of the questions that comes up very often is, what's the impact of the Fire Safety Act, particularly on building safety? And should this bit of legislation and the ongoing associated legislation be extended to cover not just buildings that are less than 18 metres, extended to cover buildings that are less than 18 metres or less than 7 stories in height? Now, that will become important when we talk about the building safety bill, but we'll come on to that in a moment. Let's talk about the Fire Safety Act and what that does, and what does that mean for us who are responsible for buildings, who are responsible for maintaining buildings, but actually live in buildings or occupy buildings. What does it mean? Well, Fire Safety Act, which is not totally in force yet, but it soon will be, has been introduced to clarify, I think, who is responsible for managing and reducing fire risks in different parts of multi-occupied residential buildings in order to prevent future tragedies occurring. Now, that bit of legislation came about a little while ago, and it brought new fire safety obligations, or maybe revised and enhanced the existing fire safety obligations to those who are a responsible person, leaseholders, building owners, managers for the building structure, etc. It extends the provisions of the RRO to the following parts of a multi-occupied residential building. So we have the building's structure, external walls, and any common parts now comes under the RRO. The external walls includes doors or windows in those walls and anything attached to the exterior of those walls, i.e. balconies or cladding. Those of you who follow the Grenfell Enquiry will be aware of how important the cladding point is. It also extends to all doors between the domestic premises, such as a flat, and the common parts. Now, unlike Article 3 of the RRO, where we just talk about the responsible person, the responsible person of the building or any part of it is the person in control of the premises. So we know that from our previous slide. But since the scope and the scrutiny of the fire safety obligations has seemingly been increased, the responsible person really will now need to review and update their risk assessment process. Once that risk assessment process has been published, the responsible person really should apply that now, that risk-based guidance to comply with their duty. So it's almost an extension of what we were aware of under the RRO. The clarification now hopefully provided by this Act means by extending the obligations of the RRO, the fire and rescue authorities can better identify who is the responsible person for the parts that we are concerned with. Think accountability. We'll come on to accountability in the next couple of slides, but I think it clears the path for enforcement action against and or prosecution of any responsible person who fails to comply with the RRO, and that can lead to unlimited fines and or criminal prosecutions. But you can't really think of the Fire Safety Act in isolation. We're going to have to think about the building regulations, which there's amendments that came into force a couple of years ago and instigated the ban on combustible cladding anywhere in the external walls of high-rise buildings over 18 metres. And then we're also going to have to think about the Building Safety Bill, which is only for high-risk buildings 7 stories or more, 18 metres or more high, which we'll talk about in more detail, but it's designed to clarify where the responsibility for managing safety risks lies throughout the design, construction and occupation of buildings in scope. We'll also touch on the external wall fire review forms, the EWS ones, which was introduced again a couple of years ago to standardise assessments on the external wall construction of residential apartments, but we'll look at that in the context of new guidance that's come in. I also don't want you to forget that we have existing legislation in place, such as the Construction Design and Management Regulations, which has duty holder responsibilities and then talks about responsibilities for principal designers and contractors. We have the Health and Safety at Work Act, as I said, and other associated regulations. Again, the question that keeps going through my mind is it all too much? Is it not enough? And how do they all work together? Is there conflict, or do they work in harmony with each other? Then we come to the Building Safety Bill. I'm sorry that this is a bit of a whistle-stop tour through the new legislation, but we are going to take our way through this. The Building Safety Bill really talks about 5 things. The regulator, the new regulator, hopefully improving competence within the industry. The Building Act revisions and looking at provisions of digital data and the golden thread of information. The definition of what a higher risk building is. Initially, it's high-rise residential buildings, but it's wider in scope, and we'll look at what the enforcement options are. The supplementary parts of the bill, which talks about the risk registers and the CPD, again, talking about competencies there, and the construction products regulations, which will determine how construction products are supplied and, more importantly, marketed, particularly in this post-Brexit climate. Let's look at a few things to do with this Building Safety Bill. I think I've got another slide on this. No, we don't, so we're going to go back, sorry. So let's talk about the Building Safety Bill in the round. What's the aim of the bill? We want greater accountability for fire and structural safety issues throughout the complete life cycle of the building. So we're not talking about a snapshot in time. We're talking about the life cycle of the building. Lots of familiar concepts here. Identifying roles to be appointed, information to be shared, activities to be coordinated. Think about construction design and management regulations, all about coordination, sharing of information, appointing the right roles at the right time to the right people, very much rooted in CDM. Which buildings are we talking about? Well, we're addressing the risks posed by higher risk buildings, but some sections have really got wider application. Higher risk buildings are generally those high rise, 18 metres, 7 stories or more. For the purposes of design and construction and refurbishment, properties with at least 2 residential units, care homes, hospitals are to be included in that. And when we relate to the occupation of a building, again, we're talking about residential properties with at least 2 residential units. Who is responsible for those? Additional responsibility, I would say, has been given to existing construction design, I'm going to say CDM actually, construction design management duty holders, including the principal designer and principal contractor. And also there are new in-occupation roles for higher risk buildings. So we have an accountable person now. So these are all new things that have been brought in. Accountable person, typically going to be the person or the organisation that is responsible for the common parts of the building, much like our responsible person. In multi-occupancy situations, there might be more than one accountable person. There you need coordination, communication between them, think CDM, very similar, and then you have a principal accountable person to be identified. Now, they are generally responsible for the fire safety, structural safety of higher risk buildings. That includes managing that thread of information, golden thread, that is going to be stored electronically so everybody knows at certain times what's happening with that building. In occupation, each high-rise, higher risk building will have an accountable person who is going to be the duty holder. They have to produce and maintain a safety case report. And again, the HSE on their website have very recently put up what a safety case report should look like. So worth looking at if you are going to be responsible for that. The accountable person has to appoint a building safety manager to oversee building safety on a day-to-day basis. Now, we talk about accountability. I think that's one of the things that really has come out of the new legislation. It's more about accountability, responsibility. Does the legislation do more for accountability of individuals? What's that going to mean for prosecutions and penalties? I think there's lots of regulation here. Could be slightly confusing, but what I'm concerned about here is not just the introduction of new legislation or new guidance, but it's the interaction between the Fire Safety Bill, the Fire Safety Act, the Building Safety Bill, the existing responsibilities we have under the Health and Safety at Work Act, the RRO, the CDM, and any other associated regulation. And in reality, it opens up the possibility of there being penalties twice or thrice over. So I think that's something duty holders do need to think about when it comes to what do I need to do as a duty holder and what do I need to comply with. I talked about the golden thread of information and what that is. One of the key changes this bill introduces is this golden thread of information about a building, which is to be created and maintained. It ensures that the right people have the right information at the right time. And that's to ensure the safety of the building. The risks are managed carefully. There are gateways that are put together. And again, I'm not going to go into too much detail about that, but you have gateway 1, 2, and 3. Gateway 1 is where planning authorities require a fire statement to ensure that the fire safety considerations have been incorporated into the design of the building. So that's kind of pre-build. That information has to be stored digitally and electronically. That's in place at the moment, that's in force. Gateway 2 and 3. So gateway 2 is when the building safety regulator wants information to show how the development, once it's built, will comply with building regs. That work can't commence until that regulator is satisfied. Gateway 3 is the equivalent to our completion or final certificate stage. That applies once construction has been completed. There's an assessment to be carried out to ensure that the work is in compliance with the law and in compliance with the previously submitted information. So different duty holders have different responsibilities at each gateway. You have a building safety regulator who, under the HSC, is responsible for giving out, monitoring consequences of non-compliance. There are responsibilities in respect of appointing and regulating building inspectors, making sure that they are competent, they can issue notices, and they can prosecute businesses and individuals. So I think all of that, really important new legislation for duty holders to be aware of. Let me get to another new section, which is about evacuation, really to think about evacuation and whether we need personal plans. So it's arguable that all buildings of any height should be subject to stringent safety measures. Of course, we understand that. But we have talked a lot about specific heights of buildings or specific stories. Does that mean things have changed enough? We know that there are still hundreds of blocks of flats that have dangerous or combustible cladding on the facades. We know that fire doesn't respect arbitrary height limits. So there's an argument that maybe the building safety bill measures should be extended now to include lower risk or lower rise buildings. Now, the government's position has always been that those buildings that fall outside of proposals remain protected by factors such as height thresholds for sprinklers, which have been reduced in previous years from 30 metres to 11 metres. But that's probably a little comfort to people who are living in buildings who are unable to evacuate quickly in a fire. Now, one issue that has been addressed has been the public consultation on personal emergency evacuation plans. Those recommendations following the inquiry, which ended in, I think, August 2001. Again, it's a lengthy document and not something to go into now, but these are just maybe tidbits for you to think about and go away and discuss. Some of the things that came out of the public consultation were things like the proposals to require the responsible person to prepare a PEEP, as we said, personal emergency evacuation plan for every resident in a high-rise residential building who identifies, they have to self-identify that they are unable to self-evacuate. There is a template to be put in place. That responsible person has to keep that information up to date, and the template, which is likely to be a one-pager, should capture key information to be provided to residents. It's already a personal responsibility under the RRO for those holding the responsible person status to ensure that everybody can evacuate or move away from immediate danger. But we need to think about what does that look like now in reality if we are thinking about the escape of disabled persons. And we need to think about how that works with current evacuation strategies. EWS1s, again, I'm just going to touch on this because a lot of this largely unnecessary perhaps, but these external wall fire review process forms known as EWS1, developed by RICS, the Royal Institute of Chartered Surveyors, to support the valuation process for high-rise residential buildings with cladding. It's not a government or a regulatory requirement, but it's an additional requirement that was suggested needed for those high-rise, high-risk buildings. The Housing Secretary a while back said that EWS1s would not be required for all flats. It would no longer be required for those under 18 metres. So removing that need would be significant, because getting an EWS one has been difficult for sellers. Mortgage lenders require the building to have this and pass the EWS one fire safety inspection. And it's been really difficult to do that. So removing that for those under 18 metres has been useful. However, the Royal Institute of Chartered Surveyors has continued to reiterate the guidance and wants it for all blocks, even with those that are about 4 or 5 blocks, which is making it very, very difficult for valuers and lenders to move forward with processes when it comes to selling properties. Really difficult. So I think while there's some lenders who will look past this, it's really difficult for those who want mortgages and still need to get this EWS1 form passed. Worth looking at, again, if you are responsible for properties of this nature. And then lastly, I just want to touch on the new guidance, which again is another introduction to our regulatory regime, the new PAS 9980 and associated guidance, which has been launched and is a direct supporting standard to the Fire Safety Act. But does it help or does it hinder our progress? What we have really is advice on measures that building owners should take to review cladding, particularly ACM, and other key safety risks, and how that should be managed properly. All of that was done in a consolidated advice note. When we now have this PAS 9980, the government has withdrawn the consolidated advice because there's been wrong interpretations, and it's driven a very cautious approach to building safety, which I think goes beyond what the government considered necessary. So PAS 9980 is a new code of practice for the fire risk appraisal of external wall construction and cladding of existing multi-storey and multi-occupied residential buildings. It sets out a methodology on how you conduct and record fire risk appraisals of walls, which can be scaled up or down in terms of complexity, and it gives recommendations for the competence of professionals who complete those appraisals. So I think as the publication of PAS 9980 and the withdrawal of the advice note is crucial to moving away from this EWS melee that we've had, or stalemate that we've had over the last couple of years. It might not solve all the problems. It's very new. Excuse me, it's very new, but it might help owners, building owners and property managers deal with the difficulties that they've had with the EWS ones and how to manage fire safety risk, particularly for those external walls. So to conclude, I think there are plenty of changes afoot, but maybe not as fast as everybody would like. There is lots of new legislation. I've touched on probably 4 bits of legislation or guidance, but it's going to take time for all of this to affect actual change. There's lots of talk about how things could be done easier and clarified, particularly for the duty holders, understanding their accountability and responsibility under our existing regime. But I think there's still some confusion, and there's certainly scope for more confusion. The Fire Safety Act and the amends to the building regulations go some way to addressing those concerns, and the Building Safety Bill goes even further than this and provides greater powers and rights to those individual residents and homeowners. The EWS forms resulted in leaseholders being unable to sell their properties at one point, and the question of who should pay for remedial works to properties, I think that's being grappled with still within government. But I think what we can say is the legislation does go far. Does it go far enough? I leave that up to you. But I think what's really important, and a really important message that's come out of all of this new legislation, is this focus on accountability for duty holders, whoever that duty holder is. And it's important that all duty holders, from building owners to contractors to leaseholders and to residents as well, understand their responsibilities and they proactively seek compliance to avoid the long arm of the law. Thank you very much.